I guess one answer to that is when you can afford him or her. On the other hand, from a standpoint of protection of the project and the producer, you really want to get the lawyer in as soon as possible. And that relates to the type of project to some extent. In any case, whether it's a picture that's based upon an original screenplay or based upon a novel and a screenplay, you need to get the lawyer in when you want to obtain the rights. It's a very dangerous thing to proceed with pre-production, the cost, effort, and sweat that's involved in getting picture arranged in the development stage without having rights to the project. Normally, one of the questions is asked is, do you have to own the rights to the screenplay or the bookend screenplay with regard to motion picture rights? The answer is that the normal way to do this, the most expeditious way to do it, and the most efficient way financially, is to obtain an option with regard to the screenplay, the novel, or whatever other underlying rights there are. And that option usually provides for a period of time, sometimes as little as a year, sometimes a year or 2 years, during which to get the project developed under circumstances where something has to be paid for the option. So I must say that that is usually the first stage of development. There are times when somebody has a treatment or a rough description of the project, which, by the way, you want to make sure gets registered at the Writers Guild to show creation, early creation, and to avoid the possibility somebody else claims that they created the project. But in that kind of situation, you're really then looking at hiring somebody to do the writing during the development stage, as opposed to a situation where someone has prepared the screenplay either on spec or based upon some arrangement with the producer.